All right, well, thank you, everyone. I'm going to quickly introduce our next round of panelists for a panel focused on platform markets and in some aspects, the introduction of the DMA here in Europe, and also what the implications might be for actors in the private market. And we might also speculate a bit on what this might mean for other jurisdictions. I'll give you some brief introductions. Our first set of comments will come from Anouk van der Veer. I should just say I'm an American, and I'm going to do my best with everybody's names. Ms. van der Veer is a new star in competition law and policy, currently working on a thesis titled Survival of the Fittest or Dynamic Competition at the European University Institute. Following her comments, we'll hear from Christophe Carvalho, who's an affiliate fellow at Bruegel. And works on digital and competition issues with a doctorate in law and economics on big data and competition law from Paris to a master in law and economics from the European Master in Law and Economics, a master in business law and a double bachelor in law and economics from Toulouse. And his academic research focuses on the adaptation of competition law to the data-driven economy and the regulation of platforms. Finally, we have Miguel Rato, who is a partner at Quinn Emanuel. In the Brussels office, whose practice focuses on competition law. He advises clients on a wide variety of issues, particularly at the intersection of IP and antitrust, but also on state and merger control issues. He's been involved in some of the leading competition cases in the last several years, including the Article 102 investigation of Qualcomm, Microsoft, Samsung, sort of a storied list of representations over the years. So we are grateful for all of them. Thank you for joining us. And Anouk, you want to kick things off?
Yes, perfect. Thank you very much, Matt. And thank you very much for the full organization for putting together this great conference and for inviting me to participate here. So I'm a second-year PhD researcher, which brings me immediately to the caveat that this is my ongoing research, and so very much work in progress. So I'm very happy to hear your comments, thoughts, questions, and afterwards. So I'm working on how to account for dynamic competition in competition law. So today I will present the application of competition law, and I will start with how do we get here, where are we today, and where to go forward. So I created this timeline to show that dynamic competition is not something that I made up or that was made up with the rise of the big tech, but it has a long history. So traces can already be found in classical economics that originated in the 18th century. What we know from Adam Smith's work on the invisible hand is that competition was understood as this process that drives prices equal to cost. Then mid-19th century, neoclassical economics originated that had a very different understanding of competition. Competition was understood as a market structure like perfect competition or a monopoly, and thereby overlooking the dynamic process that led to the market structure. Stigler once used this metaphor for race that I think is very illustrative to understand the difference between the two. So whereas classical theory understands competition as the race itself, neoclassical economics considered competition as the result of the race. So it's eventually the victory, and then the victory is the equilibrium of the market. Then we have the works of Hayek and Schumpeter, which originated in the 1940s. Hayek understood competition as a discovery and adjustment process. So to stay in business, companies need to collect information about the market circumstances and adapt to the constantly changing environments. And from Schumpeter's work, we learned that this process is driven by innovation. So the constant introduction of new products and processes brings product differentiation, and companies that fail to innovate or lag behind are likely to be replaced by more innovative competitors, which may weaken, in turn, the market power of incumbents. Then in the 1960s, Clark emphasized the importance of market entry, potential competition, to keep monopolies from raising their prices. He said that when market entry is possible, the dynamic process of actions by pioneering companies and quick responses by imitators never ends. Then in the late 20th century, the Chicago School did understand competition as a dynamic process, and the contestable markets theory allows newcomers to enter and exit, which prompts the process of competition. However, their understanding of competition is ultimately aimed at, again, a result, and the result in this case is the efficiency. So unlike neoclassical economics, the result is not a certain market structure, but it's a fixed optimal allocation of resources. And then since the late 20th century, the number of works on dynamic competition has been increasing a lot, including works of David Tees on the importance of dynamic capabilities to succeed in the process of dynamic competition, Clayton Christensen's work on disruptive innovation, and Brian Sartor's work on technology and complexity economics. So the works on top of this timeline, to me, sum up dynamic competition. However, these works have been of little influence beyond the academic debate. Antitrust policy has mostly been influenced by the works below the timeline, plus some works on innovation competition. We do see that this is changing right now. So we do see that authorities try to move the needle into the direction of dynamic competition more and more. And 3 cases are illustrated for this. The first case is the Commission's decision in 2017, the Drive.Al decision. The Commission's concern was that the merger would reduce innovation for future products. So it did approve the merger, but it was conditional upon DuPont divesting its global R&D organization. I find DuPont a good example of how we can use the tools to assess innovation competition. For example, in defining the market, the Commission introduced the concept of an innovation space, which covers the innovation efforts of R&D companies. And I think this allows for a good, or at least a better assessment of dynamic competition, because first, the merger's effects on the early stages of the R&D process can be assessed, which is difficult for market definition because there's no market yet. And second, whereas product markets only concern substitutes, innovation spaces allow to assess the competitive pressure coming from different lines of research and pipeline products. Unfortunately, the concept has had little practical impact because the Commission only used it once more after the DuPont decision. The second step in the assessment of innovation competition in DuPont was to identify at an industry level those companies that have the assets and capabilities to bring new innovations to the market. And to that end, the Commission reviewed the overlapping R&D organizations, including the resources, the staff, the facilities, and the assets needed to create and register new products, like lines of research, field testing facilities, and registration capabilities. We know from the dynamic competition literature that success in dynamic environments requires strong managerial capabilities. And the Commission takes account of this here and concludes that even though the actual number of R&D competitors is 5, only 4 or maybe even less are actually able to or have similar capabilities and assets to bring the new innovations to the market. So I think it's good to take these capabilities into account into the assessment, because it's one thing to be a potential strong innovator and competitor, but it's something else to be actually able to bring the innovation to the market to actually make it happen. So whereas DuPont was a good example, I think Facebook Giphy is overall a bad example of the use of tools to assess dynamic competition, except for the part on market definition. So in this case, the CMA ordered Facebook to sell Giphy because the merger resulted in a loss of dynamic competition. The case is, as far as I know, the only case that assessed dynamic competition that explicitly and extensively. So in the market definition, the CMA acknowledged that market definition does not allow for dynamism, so left the precise market definition open. Instead, it decided to assess the closeness of competition between Giphy's and Facebook advertising services. This way of identifying competitors, I think, reflects more of a dynamic perspective, because it does acknowledge that different products can still exert competitive pressure on each other. And because innovation competition often brings product differentiation, this is one way to identify from which competitors the actual existing competitive pressure comes. The assessment of the dynamic competition in the case is unfortunately carried out in a much more static way. I think the CMA's theory of dynamic competition is not that far off. It includes a dynamic competitor, which is the entrant that poses a competitive threat, that prompts the dynamic competitive process, which is a cycle of entry or expansion, threatening incumbents that then respond with innovation. So far in theory. But the assessment in practice, however, overlooks this exact process and assesses the results of the process. So if you recall the metaphor of the race, classical economics understood competition as the race itself and not as the result. But what the CMA eventually does, it assessed the results of the race. So it did dismiss the future plans of competitors like TikTok, Netflix, and Disney Plus because their plans are unlikely to impact Facebook's market power. So here, the CMA did not attach importance to the development on the market itself, the fact that these companies are entering the process of competition that may already impose some competitive pressure on Facebook, in response to which it has to innovate. And finally, the importance of assets and capabilities are overlooked in this assessment as well. So the CMA did highlight the value of Giphy's creative team, but also discussed the difficulties Giphy faced in appointing the right sales team and the right management team. So it did not seem that Giphy had such strong dynamic capabilities. Again, being a potential competitor is one thing, but having the capabilities to actually make it happen is something else that would have required the CMA to open up the black boxes of the firm and evaluate whether Giphy has the actual capabilities to be an important innovator. And then very quickly about Microsoft Blizzard, the CMA published its decision that it's blocking Microsoft's acquisition of Activision Blizzard 2 days ago. CMA was concerned that the acquisition would reduce innovation and choice for UK gamers. I've not had the time to read the decision in detail, but a quick search on the words dynamic competition gave 0 results. So unlike the Facebook Giphy case, the CMA did not follow a dynamic competition theory of harm in this case, which surprised me a lot because the CMA did recognize that the merger took place in the context of a dynamic market that is evolving, just as it did in the Facebook Giphy case, but it did not follow the dynamic competition theory of harm. So as we see in these cases, there's not really a coherency in assessing dynamic competition. So it's not that easy, and a lot of questions are waiting to be answered before we can put the theory to practice. So what the CMA did, its framework described potential competition. So do we see dynamic competition as potential competition, or is it just innovation competition or future competition? And how do we identify competitors when dynamic competition makes the market boundaries blurry? What about the uncertainty that is inherent to dynamic competition? How to account for this uncertainty in the competitive assessments? And how to assess the assets and capabilities? Is it part of identifying who are the competitors, or is it part of assessing the competitive pressure that comes from the competitors? And how do you actually assess capabilities? And does the dynamic competition assessment change the results? So what are the cases in which a dynamic competition assessment would have blocked a merger that was allowed by the authorities, and the other way around, what merger would have been allowed that was blocked by authorities? And finally, how to answer all of these questions without ending up with a framework that is too speculative and will not survive in court. So these are all of my future research questions, and I hope to find answers to these questions in these theories. So last year I tried to define dynamic competition with these elements. It became this dynamic competition flower. But I think I would like to use these elements to see how we can operationalize dynamic competition more than how to define dynamic competition with it. So how can these theories help us to account for uncertainty and capabilities in the competitive assessments?
Thank you, Nick. We're going to have Christoph go next. I'm going to get your slides up.
Oh, absolutely. But so as a practicing term, obviously, it's rather interesting because we have tried on many cases, obviously, to characterize to describe markets as being characterized by dynamic competition in antitrust cases and in the context of mergers. And so some years ago, this very helpful judgment from the Court of Justice was handed down in Microsoft Skype, which was the first time in which the court essentially says, oh, well, and then when the market is characterized by dynamic competition, or one has to take into account dynamic competition or what have you. Well, that has implications, including for the establishment of dominance and the assessment of market shares. And that is the reason why you will find nary a regulator who is interested in establishing that there's dynamic competition and its role, because then it has a knock-on effect on, and this is all very formalistic, the establishment of dominance, or of significant market power, which would essentially defeat the case. So that from a practicing attorney's perspective, this is the only instance in which you actually encounter in real life dynamic competition.
That's great news. I'll have a look at the case.
This one. The other one is the one. Yeah, I mean, you can try if you want. It's dynamic competition too. So I was starting with a joke. Is it working? Yes.
Yeah.
So my presentation will be more about a measure of the Digital Market Act, so it's a little bit more precise than Anouk. So I will go more into the detail of the DMA, but I think it's complementary to you, to a presentation. So I think I don't need to go too much into the detail of the DMA, because you read at least the text like 10 times and you still don't understand what does it mean. But it's totally normal. And so it's applied only to some platforms and especially core platform services. And you have basically a list of do and don'ts to respect. And what is interesting in the DMA is that you have also a provision to enforce all your acquisitions. So, but this provision informs the acquisition. It works with antitrust instruments that will mention in the next slide. So, but before explaining this instrument, I will go about the list of potential gatekeepers. So, this is a list of potential gatekeepers, not the list of potential core platform services that we have identified. So, I think there would be Airbnb, Alphabet, Amazon, Apple, Booking, Meta, Microsoft, Korak, PayPal, Salesforce, SAP, Uber, or Zoom. Obviously, just my assessment, and it's my assessment based on the two first criteria, not on the number of users, because basically I don't have access to data about the number of users right now. I mean, when I did this research question, right now I have access to data thanks to the DSA. So, but this is what I found here. And what is the issue about in these papers, and this is a research question, is how basically works the information obligation of informing all the acquisition, and which the instrument about measure review under Article 22, EU measure regulation. So you know that 2 years ago, basically, the Commission decided to change its policy about merger control, and that you will know asset referral from member state to review an acquisition, even if the acquisition doesn't meet the national threshold. And so basically, the DMA foresee that the information obligation will work with Article 22. And I will explain the next slide what is the issue about that. But the question is, what indication should trigger a measure review of an acquisition under Article 22 EU measure regulation? Because basically when you read Article 22 EU measure regulation, and when you read the guidance given by the Commission, is very broad and is largely a discretionary power. And anyway, and it's a little bit funny because the Commission said, well, we have the guidance, but even if I explain which acquisition I will review, I have my discretion to review any acquisition anyway. So it's just a guidance, but I can do ahead of my guidance if I want to. Okay. So let's check about, so the research question here is basically in the context of the DMA, given that the Commission may have an incentive to review every measure that basically he wants, which measures should prioritize, because they did a lot of measures here. And if I look at past acquisition, basically the potential gatekeepers that I identified before, they did more like 1,000 measures between 1987 and July 2022. And we can see basically that they acquired a lot of films from 1987 to 2015, and then we have a decrease in acquisitions until now. And when we see who was the biggest acquirer, I would say it's Microsoft and Alphabet that has the most acquirer here in this space. And on average, they didn't acquire a lot of films per year. Alphabet only 11, and if I'm going to Booking, he acquired only two films. There is just one caveat in the data set that I have to mention, but it's in the papers, is that I use data from French base, and this is nice because you have a lot of data here, but you may not have all the data here of all acquisitions. So just a sample, a representative of a lot of measures, but the data set may miss some measures. Yeah, but at least we have a good representation. Okay, and if I'm going about the review of past acquisition reviewed by the Commission, so all the more than one KM measures, the Commission only reviewed 21 measures, which is good for lawyers because like that they don't have a lot of jobs to do. Okay, you have a lot of jobs to do, you have enough, I guess. And only 5 didn't file, which is in EU turnover, and 2 were reviewed under Article 22 EU measure regulation. Wait a minute, it was Article 22 EU measure regulation, but not according to the news guidance. So it was the case, if I remember well, it was Apple Shazam, and the other one is in the package. But one of them is Apple Shazam. Anyway, the problem with Article 22 is that it's super nice because it's super flexible for the Commission, and I think this is a tool that the Commission wants to have a flexible tool to review every measures. That is cool. The problem is that the risk of over-enforcement, because basically they have an incentive, especially after all the speak about killer acquisition, to review every measure to ensure that basically they will not have a political backlash saying that, oh, you missed this measure whereas you have this tool. And the issue is that it raises enforcement costs for the Commission, whereas you know that they have limited resources. And for you lawyers, it creates a legal uncertainty and cost, because what do you say to your clients? Well, of course, you can go ahead for the measure, we are below the threshold, but then you say, well, be careful here, you have Article 22, where the Commission can review the measure, so be careful to close the deal. And so it may be an issue. Even so, in the guidance, we have a certain deadline and so on. And if you speak to Olivier Gassin, he say, no, look, I have already a lot of jobs, I have enough measures, so I don't have any incentive to use Article 22 for reviewing my measures. And this is what he said publicly, at least. And he say, well, look, I reviewed only one measure since the tool is in place, is illuminagral. So you see, I didn't use the tool a lot. Okay. And then the question here is, how can we minimize the cost, basically, and legal uncertainty for lawyers and economists about that. So this is the research question here, and the solution is simply we should use guidance for gatekeeper acquisition here. So here I went in deep about the gatekeeper strategy acquisition here, and I use a cluster by from a papers by a law report It was an Italian professor. I have a name in my mouth, but I cannot remember the name. But anyways, what is the report for the CMA about ex post review of merger control? And she clusters basically the acquisition. So I did exactly the same jobs, but I just expand the database here because it was just about the GAFAM, and me, I use the potential gatekeepers here. Okay, and we can see on the graph, no need to explain in detail, is that all the potential gatekeepers occur in all the clusters. And we can see what is the key insight from this graph is basically the target complement rather than compete which the acquirers. So it's more complement measure than an horizontal measure here, because if it was horizontal, you will have only one cluster and not the full cluster here. Okay. So here we have three main types of strategy. I would say the first one is internal integration. The second one is related complementors, and the third one is unrelated complementer here. Okay, so let's go for the first one. Is an app that you use every day. It's called Apple Siri, and it was funny because basically Apple acquired Siri more than 10 years ago, and Siri was a small app only available on iOS with 250,000 users, so it was very small at the end of the day, and Apple decided to acquire Siri to basically do its voice assistant. So it's purely internal integration, and I mean, I don't see any competition issue here because by doing so, you offer the app to more users and you improve the services. So the app, instead of available to 250,000 users, is now available to millions of users that we use daily and in many services. So it's an improvement. So I don't see the point for the Commission to review this kind of mergers for most of them. The second point is about related complementors. So here we have two examples because we have one is not problematic, the other one is problematic. This one is not problematic, it's about Amazon Mobipocket. So basically, so you know that Amazon starts a business by selling books, and I still buy books from Amazon because even so in France we have now this law to if you want to buy a book online you have to pay €3 basically to protect the small publishers. But I mean Amazon have more shows, so I'm using Amazon. And Amazon decided to enter into the ebook industry in 2007, and he started by Mobipocket. And he did a series of acquisitions to enter into this market. And basically, again, it just increased the offering and give more choice at the end for users. And right now, Amazon offer a lot of ebook and a lot of book, and you can even read a book in streaming if you want, like Netflix. So for me, it's an acquisition that doesn't pose any competition issue. However, whereas it can pose competition issue is about Facebook, Instagram, for example, whereas a complementer. So Facebook was, at the time of the mergers, just a social media, and Instagram was basically just a photo app. And it was reviewed only in the US and in the UK. In the UK by the former CMA, which was the UFT. And the UFT in the 10 pages say, no, basically I don't see any competition issue here. The possibility of advertising is very low, people don't use the app and so on. And basically there are no social features here, just reviewing your photo. Okay, nice. But Facebook was also the first app to share photo here, and Facebook was not available yet on mobile. So the difference between Facebook and Instagram is that Instagram was a photo sharing app on mobile. And by doing this acquisition, basically helps Facebook to enter into the mobile ecosystem and to compete, which also and to keep its dominance in photo sharing. Okay, so this may be problematic. Now about unrelated complementor here. So we have, for example, Apple that acquire an autonomous car manufacturers. So again, I don't see this kind of acquisition problematic in a way that basically you have providers in the tech sectors that try to compete with car manufacturers. I think considering the concentration of car manufacturers, it is maybe a good idea to do so. Of course, one may argue that it's problematic in a way that then if the autonomous car become mainstream, Apple will dominate the market. Sure, it's a potential treat in a nascent market. Perhaps the CMA will block the mergers in the futures, but I don't think it will be wise to do it in a way that, again, we have already car manufacturers, and if they want to compete in this market, they can do it. So anyway, the competition will be there. And then where there may be an issue, whether is this kind of acquisition between, for example, Facebook and Oculus in 2014. So at the time, Facebook already was in a situation where, well, social media may not be mainstream in the future, so you have to understand what will be the next generation of device. And he says that, well, VR may be the next generation of device. And this acquisition, which a series of acquisition, basically was, and the last one was Meta. In the US, it was Meta and the application. Well, Vision, Meta Vision, and so it's helped basically Meta to dominate the market, and this may be problematic because if there is a series of acquisition to try to dominate the market, it may be an issue. Okay, so now I want more in deep into the gatekeeper acquisition in relation to core platform services, because this is where basically the DMA is about. It's about core platform services. So check which application could be into the consideration of core platform services. And there were basically 130 acquisitions in the past that could have been into these categories. And we can see that most gatekeepers book a firm into at least 2 core platform services. So the first insight is, well, there's a strategy of diversification here. So let's try if it's true or not. So then I'm going into more focus on the distribution of the acquisition here. And what we can see is that they focus on distribution into their main core platform services. So, for example, Alphabet acquire more firm into church, or Amazon more into online intermediation services. And so, first of all, there is a strategy of consolidation and into their core platform services. So what they do is best, and then they try to expand into new markets. And we can see that some acquisition basically enables the gatekeeper to dominate the core platform services. So, for example, Google YouTube in 2006. And so what are the recommendations for the Commission and for the news guidance, basically? The first one is, like I said, what is problematic about the acquisition between Facebook and Instagram is that they were both an envelope of users here. And basically, right now, I'm not using anymore Facebook, but I'm using Instagram because for me, it's like a substitute. So this may be problematic because we can see that the consumer will shift from the acquirer to the target in the future. So here, this is something that we have to target first. This is when the target consumption usage develop with the acquirer. The second one is when the target is a leader in a future critical market. So this is the case with Facebook, Oculus. So the question is, how do you define critical market? I explained in the papers. And the third one is when the target is active in a core platform services, because this is the aim of the DMA, and any acquisition in the potential core platform services will de facto reinforce dominance in this space. That's all for me, and thank you.
Thank you very much.
Miguel, when I think about platforms and some of the original work in the 80s and 90s on network effects, often this unfolds in the context of IP. But maybe if we get your thoughts on what the current state of play is, maybe that's not quite as dynamic of a space as it used to be.
So it's interesting because that was obviously your thought when you first asked me to be a part of this panel as well. Given that you do a lot of work on the section of IP and antitrust, what are the implications now with the DMA? And as I told you then, well, I'm sorry, but I think my observations will be very, very short.
No.
Essentially, there's very little to say about it. If you read the DMA, do a keyword search, you will not find the words intellectual property. And thus, the way I see it, it's likely that you will have some issues regarding interoperability. And as I'm sure you have read, the DMA provides for free of charge access. Interoperability for business users, free of charge. What that means is that it's possible, even likely, that some of the mechanisms to provide interoperability will be covered by IP. You can take software, either patents or copyright, know-how. That there's no reference to this in the DMA. So in a way, you could view it as, to the extent that interoperability will be achieved through the use of mechanisms covered by IP, this would be a form of compulsory license. Now, that IP is going to be what is like. Now you will have also and the EU patent, but they will be covered by IP that is member state law. And thus you have sort of an encroachment of EU law on rights which are regulated by member state law. That seems to be probably the only area in which IP will come to the fore in the enforcement and the application of the DMA. It's possible that you will have other areas, other aspects of the enforcement in which perhaps a defense will be, but this is covered by IP. This is proprietary. Access can be granted, but cannot be free of charge. It would be cost to do so will incentivize. Children, in fact, will incentivize innovation, etc. All of the traditional.
Right. Yeah. I think that's really helpful. Maybe just kind of putting on an adjacent hat that you wear, just more generally advising clients on the new the dynamics with the introduction of the DMA and Unrelated. I mean, how does that play out?
Well, as you can expect, there was at first a scramble. Any company providing core platform services, facing the risk of being designated a gatekeeper, having to self-assess, they scramble to find advisors, essentially. and then also scramble from lawyers in private practice to offer their services. A scramble also to fill compliance roles. And those who know for sure, helpfully listed just a minute ago, those who know for sure that the regulation was made for them, staffing the compliance function. A simultaneous scramble from those that will use the DMA offensively to do the same, start to consider possible complaints, start to consider possible arguments to be used, the assessment of business practices by those who are likely to be designated as gatekeepers. Essentially, on the one hand, defensively, what do we need to do to comply? We need to do our self-assessment ex ante. What is our exposure? What are the areas in which we know we will face complaints and in regards to which we may have to modify our behavior? And then, offensively, we have how can we use this to as a weapon, as a tool. Sure. So this is what we've been witnessing, and obviously at this stage the answer to most things is, well, we don't know. No one knows how this is. Do we have a credible case? The overwhelming majority of the individuals doing this type of social advisory work comes from competition and and you tend to when all you have is a hammer, everything looks like a nail. So you're going back to the concepts you use from Antitrust when you're providing advice. I was just telling you this how the DMA, the enforcement, the application of the DMA is going to result. In my view, it's going to result in widespread litigation, and it's not going to be simple. And just one example is the use of the word "same" in the provision relating to access or interoperability, to provide access to the same hardware or software features in the operating system, for instance, of those same as those that the gatekeeper uses. What is same in this context? It is identical. How is it even possible? In many cases, technically, it will not be possible to have precisely the same. And so, question for the lawyers, for the antitrust lawyers: look, this is what this gatekeeper is doing. This is how they provide access, free charge, interoperability. Is it the same? Are we in some way being discriminated? Is some discriminatory angle here? This is going to be par for the course. It will be many years before we have any clarity on this issue. It will be many years before you have judgments from the Court of Justice. This will all end up before the Court of Justice. The question will be, well, is the provision being complied with? And does I view this, and concurrently you will have in all likelihood the same arguments being made also from the perspective of Article 1 and 2. So you're going to have these two strands. They may lead to different results, and businesses will use both tools simultaneously because it's in their interest, either in offense or on defense, because it multiplies their chances, doubles their chances, and maybe getting the desired outcome.
Yeah, no, that's really interesting. We are standing between everybody and lunch, and so I just wanted to ask one last question. I think part of this is I think a lot of our Zoom participants are joining us from the United States, and that'll be a significant amount of those watching recordings also. So I wanted to just talk about something that I think might be obvious to everybody sitting here in Europe. It was raised with some of the things that were on Nuke's slides and comments, but the role of multi-jurisdictional reviews here, competition between different jurisdictions, and particularly an invigorated Competition and Markets Authority post-Brexit in the UK. I don't know if this is a particular question for anybody, but how does that dynamic play out within this substantive area?
I can offer a few observations.
Yeah,
you're entirely right. There is no competition. It takes place at many different levels of the substantive assessment. Obviously, we can expect that the CIMA will not diverge. I think it's clear that they want to do their own thing, and they want to establish themselves now as a non-EU jurisdiction, not bound, going forward by the same rules. You are also witnessing now, competition at a jurisdiction level, and the well-precedent application of Article 22, the power cost judgment. So on the one hand, you have now the Court of Justice making it clear that the competition agencies of the member states can apply the Article 1 prohibition to mergers, to mergers that have been. You have this ability for the Commission to invoke jurisdiction in circumstances where the thresholds of merger regulation are not met upon referral from a member state who itself would not have jurisdiction over those states' own rules. And that has created a very complex system which you have both some competition regarding the substantive assessments and the application of the law to these mergers, and that's just within obviously the EU, which I guess your question was just about within the EU, not necessarily traditional competition
transatlantic.
It's in the other. So
That's very helpful. Thank you. We are a little bit over time. I'd like to just highlight a couple of ties before we go to lunch, which is, I think, Anu's comments nicely set up. I believe some of the things we'll talk about with Dr. Schreppel at her second keynote at 1 o'clock. And Christoph, your comments on mergers will also, I think, inform the discussion we'll have in our final panel today at 4, which looks more closely at merger control. And thank you also, Miguel, for the perspective from practice, which this is a little conference weighted a bit on academic insight, so it's nice to get the full harsh reality of practice from time to time. But if you'll join me in thanking everybody.